thank you.
All right, thank you. Good evening, everyone, and welcome to the meeting for the Maryland State Commission on Criminal Sentencing Policy. My name is Judge Dana Middleton, and I am here with Dr. Soule, and we want to welcome you to our second meeting this year. Do we have a quorum?
We do have a quorum.
All right, thank you. Has everyone had a chance to review the minutes that were sent out? Has everyone had a chance to review the minutes?
Yes.
Are there any proposed changes to the minutes? Any proposed changes or corrections to the minutes? If not, can I have a motion to approve the minutes as submitted?
Motion to approve.
Okay, I'm gonna say, who spoke first? Who spoke?
Mr. Zaremba spoke.
Yeah.
Okay, I'm gonna say Mr. Zaremba spoke and Mr. Finchy second. Oh, did I have a second? Thank you. All right, it's been moved and properly seconded that the minutes that were submitted be approved. All those in favor?
Aye.
Any opposed? Thank you. Motion carries. Next on the agenda, we have the Guidelines Subcommittee report. I do see Judge Shaw and Judge DeLeonardo present. I believe they only have a few items to report. Do we know which of you is going to present to the
I think we're
commission?
going to defer to staff.
Okay, thank you.
Yeah, thank you so much. So we'll be dividing it up among our staff. The Guidelines Subcommittee met via video conference on August 29th. We had a good meeting, and so we'll be reporting on 3 items. And the first item that we'll be discussing is the continued review of the common sentencing guidelines departure reasons. And Stacy Najeka is going to present this issue for our discussion.
Thanks, Dave. So I will refer you to the memo updating list of common departure reasons. Most of the information in this memo was presented during the commission's last meeting on July 9th. At that time, commissioners reviewed proposed revisions to the list of common departure reasons. Those proposed revisions were guided by a survey of Maryland Circuit Court judges and existing data on sentencing guidelines departures. During the July 9 meeting, concern was raised over the proposed removal of the mitigating reason offender had diminished capacity for judgment. Specifically, it was noted that removal of this reason may make it more difficult for judges to report downward departures due to the defendant's past or present intellectual or mental health concerns. In response, the commission voted to send the issue back to the Guidelines Subcommittee for further consideration. The subcommittee reviewed this issue during its August 29 meeting and agreed to recommend the removal of the reason offender had diminished capability for judgment, and in its place, the addition of the reason offender is or was suffering from a mental or physical condition that reduces culpability for the offense. This phrasing draws from a similar departure reason in Massachusetts and addresses the concern raised in the July 9 meeting. This proposed revision, along with those that were previously reviewed, are located on pages 3 to 5 of the memo. The Guidelines Subcommittee unanimously recommends adoption of the proposed updates to the list of common departure reasons and the corresponding instructions. That concludes my summary, and I'm happy to answer any questions. Otherwise, I will turn it over to the commission for discussion.
I would just note that the language from, I believe it was Massachusetts,
Yes.
you changed a little bit in subcommittee by deleting substantial, the word substantial, and leaving it up to the judge to make the determination as to whether it was worthy of reporting. And with that, unless Judge DeLeonardo has anything further, we would ask for the commission to vote.
All right, thank you. So there's a motion on the floor to accept the list of common sentencing guidelines departure reasons as presented. Is there any discussion? Yes. Delegate Bartlett, did you have a question?
I do. I have a question.
Okay.
I wanted to ask a question of the subcommittee as to why. So I thought that the judges would be looking at the capacity of the individual at the time of the time when the crime was committed. So is that correct? Just so I'll make sure I'm working on the right premise. Okay. So the language is concerning to me because there could be a physical ailment that came after the crime was committed, or a mental ailment that came after the crime was committed. So I hate to throw a monkey wrench in there, but it read kind of weird to me, and I was just wondering if that had been discussed in subcommittee and if there was a rationale to it.
So we asked, go ahead.
Hmm.
Judge?
Oh,
You-
I'm happy to. Yeah, that was discussed. So there's actually two factors listed. If you see number 3 is that they were suffering it at the time of the offense. But factor 4 is offender's age and health, which very often will be something that would be considered at the time of sentencing. So there was actually a discussion that we did have in wanting to keep both of those factors in, because one would deal primarily with the issue at the time of the commission of the offense, and one would deal at the time of sentencing. And it may exist in both, but it sometimes may exist in one. And one of the examples that I had given was a case that I had where someone had been making pipe bombs and one of them exploded. So they didn't have those issues at the time, but by the time they were getting sentenced, they had very significant health issues as a result of the injuries they suffered. And that obviously is a factor in sentencing. So I do think we capture both with those two factors together.
Thank you for that clarification. That makes sense.
Thank you. Are there any other questions? Any further discussion?
I do see Mr. Zarimba's hand raised.
Thank you.
I'm sorry, I'm not seeing it on my screen. Is that?
Oh, okay. You know what? I think that was my cursor that becomes a hand when I move it over. I apologize. It just happened to be over your image. So I
You just wanted
apologize
to
for
put
that.
your hand over my face, you know.
Well, let
I
me
got
take
the
this.
message. I got
Yep.
the message.
Let me take this opportunity to thank Mr. Zarimba for meeting with the staff to work through this proposal that we came forward with to address the concern that was raised at the July meeting. So maybe that was an opportunity. I wanted to, subliminally, I must have told myself I wanted to acknowledge your help on that. So thank you, Mr. Zarimba.
Thank you. All right, so is there still the motion to adopt the recommendations of the guidelines subcommittee to approve the departure reasons, the reasons for departure of the guidelines? Yes, all right, thank you. Is there a second?
Second.
Saunders, there's several. Saunders, Mr. Finchie. Okay, Mr. Harvey. All right, thank you. It's been moved and properly seconded. All those in favor?
Aye.
Aye.
Thank you. All those opposed? Thank you. Motion carries.
All right, thank you. I will be presenting the second item on the guidelines subcommittee report, and this is a review of offenses involving threats to public officials. And I refer you to the memorandum that was distributed with the same title. As you may recall, the subcommittee at its June meeting recommended that staff review offenses involving public officials. This was after the subcommittee recommended a seriousness category 5 for the offense of knowingly publishing personal information of a protected individual if the individual knows or should have known that publishing the information poses an imminent and serious threat to the protected individual, and its publishing results in assault, harassment, trespass, or malicious destruction of property. For those of you who may recall, that is the Judge Andrew Wilkinson related legislation that came out, and the Sentencing Commission classified the corresponding offense. When the commission was working on classifying that offense, the subcommittee expressed concern that a similar offense, which is threatened to take the life, kidnap, or cause physical injury to state or local official, deputy or assistant state's attorney, or public defender, was classified as a seriousness category 6 person offense. So staff presented a review of offenses involving public officials to the guidelines subcommittee at its August meeting. Based on that review, the guidelines subcommittee recommends that the commission take 2 actions. First, the subcommittee recommends that the commission reclassify threaten to take the life, kidnap, or cause physical injury to state or local official, deputy or assistant state's attorney, or public defender from a seriousness category 6 to a seriousness category 5 offense. So to increase the seriousness category by one level. Now, it's important to note that the reclassification will not impact the guidelines for the particular offense, as a seriousness category 5, 6, or 7 offense all receive the same 1 point in the calculation of the offense score. But it could impact the calculation of an individual's prior criminal record. It also recognizes the serious nature of the offense and places it in a seriousness category that's comparable with assault second degree. Page 3 of the memo provides a summary of the recommended reclassification and a list of comparable offenses. Second, the subcommittee recommends that the commission classify one previously unclassified offense that involves public officials, and that is a violation of Election Law Article 16-205. Election Law Article 16-205 prohibits a person from interfering with an election official in the performance of their official duties or interfering with an individual lawfully present at a polling place or at a canvass of votes. A person who violates this law is guilty of a misdemeanor with a maximum punishment of 1 year incarceration, a $50 to $100 fine, or both. The subcommittee recommends this offense be duly classified as a seriousness category 5 person offense and a seriousness category 6 property offense. The person who initiates the sentencing guidelines worksheet, so that would be typically the prosecutors or parole and probation agents if a PSI is ordered, would have the discretion to classify it as a person or property offense based on the specific facts of the case. The dual classification recognizes that the act underlying the offense could be a person or property related offense. We had a lot of discussion about this, and ultimately the subcommittee concluded that it really could be either. There are other dual or multiple offense category classifications that already exist in the guidelines offense table. So for example, accessory after the fact to a felony is listed separately for property, drug, and person offenses. So the person in completing the guidelines must select the corresponding offense type in that scenario. A seriousness category 5 is recommended for the person offense version. That is based on the classification of comparable offenses such as threatening an election official or their immediate family member. A seriousness category 6 was recommended for the property offense version, and that was selected based on comparable property offenses, and because the recommended guidelines ranges for these offenses are comparable to those for category 5 person offenses. Page 4 of the memo illustrates what the guidelines ranges would be for this offense if it was a person versus a property offense. Page 5 through 6 of the memo provide a summary of the proposed classification and a list of comparables. So I present these 2 recommendations from the guidelines subcommittee, and I'll turn it over for further discussion.
So I would just note that in the words of Mr. Fency, because of the environment and culture that we live in, we thought it was important to, first of all, provide consistency and to state that these offenses should be taken seriously, even though in the end, they do not impact the sentencing guidelines. But I don't know whether Mr. Harvey wants to say something, because he really brought to our attention this issue with respect to state's attorney's offices. Mr. Harvey?
Thank you. It is very important. And I think for the sake of consistency, if we classify the one offense manner, we should
Oh, you
You're-
went on mute again.
go on. I'm using a laptop. It's not working so well. And I think my colleagues in the State Attorney's Office would support this move.
And it's for public defenders as well. Mr. Zim?
Yes,
Yes.
I've
Sorry.
actually been around long enough. I remember when the statute did not include public defenders, and
Wow.
I actually had a client who was like more threatening me, but he kind of offhanded made a comment about the judge, and all of a sudden I had detectives descending upon me, and it was like, oh well, glad the judge is safe, but they've since changed it.
Well, I am currently under threat from a defendant, so I support this.
Okay. Is there any further discussions or questions? Did I hear someone? Okay. Are there any questions about the other recommendation regarding dual classification of interference with performance of official duties of an election official or individual at a polling place?
We just had the question of whether there should be the dual classification. Is that the one? We had a long conversation about it, and we talked about the fact that it could be a property crime, it could be a person crime. And so an abundance of caution to, just make it a dual classification, and hopefully that will cover everything. With that, we would recommend or move that the commission accept the recommendations.
Thank you. It's been moved. Is there a second? Thank you, Ms. Saunders.
Saunders.
All right, thank you. It's been moved and properly seconded to accept the recommendations of the guidelines subcommittees regarding those two offenses. All those in favor? Thank you. Any opposed? Thank you. The motion carries.
Thank you. We will move on to the third and final item on the guidelines subcommittee report. And this is the review of committing a crime of violence in the presence of a minor. And I am going to turn this over to Bella Nozell, who's our one of our recent additions to our staff. She started with us in June, right, Bella? It was in June?
Yes,
Yeah.
no, July.
July. Okay, but yeah. Okay, great. Well, we're happy to have Bella with us and happy to hear her report about this particular issue.
Awesome, thank you. I will refer you all to the memorandum titled Review of Committed Crime of Violence in the Presence of a Minor. This is a status update only. The Guidelines Subcommittee does not recommend that the Commission take any action. For background, as you know, the Commission at its July meeting agreed to review the classification for this offense. This was after the subcommittee recommended a seriousness category 5 for the offense of indecent exposure when person knows or should know that a minor is present. Commit a crime of violence in the presence of a minor was listed as a comparable offense for indecent exposure when person knows or should know that a minor is present, and Delegate Bartlett expressed concern that it was the only comparable classified as a seriousness category 6. The MSCCSP staff presented a review of this offense to the Guidelines Subcommittee at its August 29th meeting. The review included characteristics of the offense, sentencing guidelines compliance rates, and average sentences for this and comparable offenses. Those analyses are provided on pages 3 through 5 of the memo. As you can see, the MSCCSP has received worksheets for only 41 sentencing events involving committed crime of violence in the presence of a minor since the law went into effect in 2014. That's a relatively small number of offenses. The subcommittee does not recommend that the Commission act with respect to reclassification for 2 reasons. First, the sentencing guidelines compliance rate for this offense was relatively high at 83%. Second, by definition, this offense is always convicted with an underlying crime of violence. Per Criminal Law Article 5-603.1, the sentence for this offense shall be served consecutive to that of the underlying crime of violence. Pursuant to the Commission's recently adopted mandatory consecutive sentence offense rule, the upper limits of the guidelines range for an offense that is statutorily required to be served consecutive to that of another offense shall be added to the upper limits of the guidelines range for its underlying offense. So, the overall guidelines range for a sentencing event involving committed crime of violence in the presence of a minor is already enhanced. Reclassifying the offense would have no impact on the recommended guidelines range or the calculations of an individual's prior adult criminal record score. This concludes my summary. We are happy to answer any questions. Otherwise, I'll turn it over to the Commission.
Thank you, Bella. I just want to interject there because that might get a little confusing. Like the subcommittee's rationale, and I think any of them can jump in and correct me if I'm not saying this correctly, was committed crime of violence in the presence of the minor is different than what we just talked about with the election officials offenses or threatening a because it has to be sentenced in conjunction with another offense. And that other offense is going to always be, it's going to be part of one similar criminal event. So it doesn't impact the prior criminal history score. It would never do that because when you're calculating the prior criminal history score, you take the most serious offense within a particular criminal event. And so committing a crime of violence in the presence of a minor is always going to be combined with an underlying crime of violence that's going to be the most serious offense. So this, in that way, changing the seriousness category won't impact the prior criminal history score. And then the other uniqueness about it is because it is statutorily required to be sentenced consecutive to, we already changed the guidelines to address all those, I think it was 10 specific statutes that require a particular offense to be sentenced consecutive to another count. So in that instance, the guidelines are already being adjusted. So the subcommittee thought for those reasons, if we moved it to a 5, it would have no impact whatsoever. So it is different than what the other offenses that we just talked about. So for that reason, there was no recommended action.
Okay. Well, I'm not sure if they're asking us to adopt their recommendation that we take no action. Is that the motion that we?
I don't think a motion's
take no. I mean, do we need anything?
It's more of an informational report, and
Thank you.
we're not requesting any action.
All right.
But we did want the Commission to understand the rationale behind the decision not to change anything.
Thank you. Now, if there's nothing further, we will move forward with the Executive Director report, Dr. Soule.
Yeah, so before I do that, I just to wrap up the subcommittee items, one of the things I thought I'd bring out is, so the first 2 items on the subcommittee report, we took action on. And so that involves, typically when this commission takes actions on items, the staff will then initiate the process to adopt those changes through COMAR. And that is, for those who don't know, that is a process that takes about 3 to 4 months to go through, depending on when we first initiate the process. However, with that being said, we can't immediately start that process this time because we currently have pending updates to the sentencing guidelines that will be adopted effective November 1. And we are not allowed to propose amendments to anything in COMAR that is currently pending changes, if that makes sense. So the changes that we have coming will go into effect November 1, so we can then start the process of submitting these changes that we voted to adopt today, immediately after November 1, which means that if they were to go through in a timely manner, 3 to 4 months, you're looking at a March expected adoption date. With that being said, I would like to reserve the right to report back to this commission at our December meeting, where the staff would also like to check in with our programmers about the timeline for when we can implement the corresponding changes that were adopted today in MAG. So if for some reason, and we don't necessarily anticipate that, there seems to be some length and time that would take to do that, we might choose to have these adopted at a later date. For example, the staff was thinking like July 1 might be a good date because that's the start of the new fiscal year. And for those that are familiar with our reporting techniques, the annual reports and most of the reports are doing, we do analyze data on the fiscal year. So starting with a July 1 start date does make sense for for the changes that were adopted today. So I just wanted to give you all a heads up about that. And our plan would be to circle back to you all at the December meeting once we've kind of figured out, the timeline for adopting changes in MAGs, et cetera.
All right, thank you. Are you ready to move forward with
I am.
All right, thank you.
Well, I have 6 items to review today in the executive director report. The first item is I just wanted to let an announcement to announce that we do have a new graduate research assistant that has joined us, and her name is Julia Katzbaro, and she started with us at the end of August. Unfortunately, Julia has graduate class tonight, and she is a graduate student in the Department of Criminology and Criminal Justice, and we're excited to have her. She is going to be taking the place of Lydia Becker, who you all got to know over the last year. Lydia did a great job for us, and we really wanted to thank her. Unfortunately, she also has class tonight. Otherwise, she would have joined us. So Lydia was awarded a fellowship, which was a great honor for her. A federal fellowship that requires her to focus exclusively on her dissertation for her doctoral work. So she was not allowed to continue as our graduate research assistant. But we are happy to welcome Julia, and I look forward to hopefully being able to introduce her in person to everyone at our December meeting, pending her schedule, which again, graduate classes are usually in the evening, so can be tough for her to participate in these meetings. The second item that I wanted to discuss was the forthcoming November 1 updates to the sentencing guidelines. As I just noted, we have a couple pending updates to the INCOMAR. They were published in the August 23rd edition of the Maryland Register, and if everything goes to plan, they will be adopted effective November 1, 2024. Those specific amendments were to modify regulations 12 and 14 under COMAR 14.22.01, and those are to specify how the mandatory consecutive sentences offense rule works in combination with 2 or more seriousness category 1 or 2 offenses, and the multiple victim stacking rule. If you recall, that's something that we addressed at our recent meeting to just clarify the rules in those unique scenarios. Additionally, the proposed amendments modified the offense table to reflect the new and revised offenses from the 2024 session that we discussed at the July meeting and voted on their classification. There was also one previously unclassified offense that the commission classified, and we revised the seriousness categories for 2 offenses. So those proposed amendments are expected to be adopted effective November 1, 2024. The third item I wanted to update was about the work of the Sentencing Commission in terms of our training schedule. Our training coordinator, our wonderful training coordinator, Catherine Pembroke, she will be hosting multiple training sessions, actually starting this week, tomorrow, starting on September 11th, and on the 20th, Catherine will be hosting a MAGS 101 webinar for all justice partners, including defense attorneys, prosecutors, and parole and probation agents who are initiating the sentencing guidelines. And then on September 13th, Catherine will provide an orientation for judicial law clerks and other judicial staff, and that'll be more focused on the role that the courts play in terms of providing sentencing information in MAGs. That session will also be repeated on September 25th, so there'll be 2 sessions for each group. Additionally, I have scheduled sentencing guidelines feedback meetings with all the judges in both the first and the second judicial circuits. Those meetings will be completed in the last week of September, and I'm looking forward to meeting with those judges. And additional meetings are being scheduled for Allegheny and Washington County in the coming months. I've said this before, my goal is to meet with each jurisdiction every 2 to 3 years. I try to meet with the full bench whenever possible, and there really are a great opportunity just for me to, share some data that is specific to the individual jurisdictions, but also just to make sure I'm making them aware of any recent updates or changes to the sentencing guidelines, and to, highlight the work that the Sentencing Commission is working on at that particular time. So looking forward to completing meetings with quite a few jurisdictions here in the coming months. The fourth item that I wanted to discuss was just the protocol for the December 3rd meeting. I know we have a few commissioners that are new with us this year that didn't take part in the traditional public comments hearing that we are statutorily required to hold. So we hold that meeting traditionally every year in December, and we do a dual meeting where we start with a public comments hearing and we follow it up with a regular business meeting. So our schedule will tweak it just a little bit. We will start at 5 p.m., get started a little bit earlier to have the public comments hearing, and then we will take a very brief break, grab some dinner, and come back into the meeting room for our regular business meeting. Starting next month, we will distribute an invitation to key criminal justice stakeholders throughout the state to make them aware of the hearing and to ask them to distribute it among their groups to make sure people are aware of the public hearing. Our intention is to allow an option for those who are interested in speaking to do so virtually, but we'll encourage in-person attendance because this will be an in-person meeting at the Judicial Training Center in Annapolis. And then finally, just I have a request for all of you. I just want to encourage you to think through if there are any appropriate and thoughtful speakers who you think would be good candidates to speak at the Sentencing Commission public comments hearing. If you can reach out to them or send them in my direction to speak to me if they wanted to speak about any sentencing policy issues that fall within the scope of the work of the Sentencing Commission. So I just encourage you to suggest that interested speakers reach out to me if they have any questions about the public comments hearing. The fifth item that I wanted to talk about was the Commission's plan to produce a 25-year anniversary commemorative booklet. I did note this, I think previously, I know I did previously, that 2024 this year marks the 25-year anniversary of the creation of the Sentencing Commission here in Maryland. And in recognition of this milestone anniversary, the staff has been working to prepare a commemorative booklet to recognize the service of our many commissioners over those 25 years and to highlight the significance and the value of the work that the Sentencing Commission does. In the coming weeks, the commission staff will be reaching out to a few current and former commissioners to solicit comments to include in the booklet. We are really focusing on just getting real short snippets from specific individuals to hear their thoughts about the work of the Sentencing Commission, and we want to see if we can take those and include those in this booklet. I think that'd be really nice. Our goal is to complete the booklet in advance of the December 3rd public comments hearing to make it available, have printed copies to make available for all of you, and also to eventually distribute among our listserv and put on our website, et cetera, just again, as a way to recognize all the important work that this commission has completed over the last 25 years. And then last thing that I wanted to report on was just to give a status update on the work of our sister organization. I don't know if I would call it a sister organization, but another committee that has been established in the state. I have spoke about this at the past two meetings. That's the Maryland Equitable Justice Collaborative, MEJC for short. As I noted at the July meeting, the Maryland Equitable Justice Collaborative was created in October of 2023, so it's just over almost a year old now. It was a joint initiative that was led by the Office of the Attorney General and the Maryland Office of the Public Defender, with the goal of reducing mass incarceration of African Americans and other marginalized groups in Maryland prisons and jails. The goal is to examine the scope and the cause of the crisis and to develop a plan for reform and to make recommendations by January of 2025. So right around the corner now, and I think the collaborative hopes to have some action items for the upcoming legislative session. To achieve this goal, the collaborative forms 7 work groups to focus on issues that drive incarceration rates. One of those work groups is the Criminal Law and Sentencing Reform Committee, of which I was invited to join. And that committee is co-chaired by Katie Dorian, by our own Katie Dorian. Hi, Katie. Sorry to put you on the spot. Katie is the Attorney General representative. It's also co-chaired by Judge Alexander Williams, and from the public defender side, from Sean Mukherjee, who is the acting district public defender for Montgomery County. So that committee, of which I am a member, started meeting in December 2023, and we have been meeting pretty regularly, bi-weekly, pretty consistently, to come up with ideas. The MEJC leadership reviewed multiple ideas that were proposed by the committee and ultimately directed the committee to act on 3 priority items. The first was to authorize a study of racial and jurisdictional disparities in the charging, conviction, and sentencing for certain drug and violent offenses, including felony murder, robbery, and sex offenses. The second priority was to create a pilot program that requires judges to use a risk needs assessment tool to be developed in consultation with the Department of Parole and Probation during sentencing. The third priority is to reduce unnecessary pretrial confinement by changing the district court discovery rules so that prosecutors must give discovery to the defense within a reasonable time frame and develop a uniform civilian complaint review process across all the state's attorney's offices. So the committee has been instructed by the MAJC leadership to finalize proposals, and our committee has been working on that. That the Sentencing Commission staff was really helping the committee in particular with the first proposal about studying racial disparities. We highlighted some of our own findings and research that we did recently with our July 2023 report. And we hope that that's been helpful to guide the direction of the MEJC proposal. The MEJC expects that those proposals will result in proposed legislative actions during the 2025 session. I will continue to provide any updates to the Sentencing Commission regarding notable developments that come out of that committee in particular. So that concludes my report. I'm happy to address any questions.
Any questions? We have a few members of the MEJC. Does anyone, do any other members, right? Do any other members have anything to add? That they want to bring up?
I'm also on the MEJC, and we have been looking at court involvement and how we can help individuals to be released. I know that I gave a presentation on reentry court, excuse me, and also the question of second chance legislation. So there are a number of perspectives, excuse me, that are coming together. I'm just not confident about the January deadline.
Yeah. It seems ambitious. But I think that is still the plan.
There's a lot of work being done. So many people involved, ex-offenders, law enforcement, correctional, there are all types of organizations involved. And they really are, everyone is really working very hard, but I just view it as overly ambitious that'll be done by January. But that doesn't mean it won't continue to get done.
Right.
Well, that's good. Sounds
I
like
think
good.
oh, sorry.
Go ahead.
I was just going to say, I think there will be, I agree. It is, we've all sort of expressed, observation that that's a very ambitious deadline, but I think there will at least be something. I mean, there is a report due at the end of the year, so there will be some recommendations. I think the next collaborative meeting is October 15th, where the collaborative as a whole will be voting on each committee's recommendations. And so we will at least know what goes into the report. We have, as a collaborative, contracted with an outside research group, and they've been great and have been really like helping put these proposals together to get it into shape, by December. But I think, Judge Shaw, that's a great point, that it might not be everything that we've discussed. I think there will be some things that make it into that report, and then the rest will be ongoing. This has been, the Attorney General and the Public Defender said from the very beginning that this is supposed to be a long-term plan, because you can't say that you're going to combat these issues and expect to be done by the December report, and nobody thinks that, and we don't want to lose momentum. So I think, some of the things that will go into this report, hopefully will be the things that David just outlined, but there are so many more, and I'm sure in your committee as well, there are so many more proposals, recommendations, thoughts that people have that are going to be years in the work. So, and we're open to any thoughts that people have, any folks who want to participate. I mean, we have tried to cast the net as wide as possible, but we're always happy to have more people and more voices and more brains. So the more the merrier. And feel free to reach out to me if you're interested in any of those committees.
Thank you. Thank you to all of you for sharing some more information about your respective committees and all the work that you're doing there. So I guess moving on in the agenda, just want to bring to your attention upcoming meetings. We've already discussed the December 3rd meeting, public comments. And just that the business meeting will start 10 minutes after the public hearing. Any old business? Any old business? No. Any new business? Anything new? Anything new? Yes, Mr. Harvey. It's almost more fun to see your reaction. It's almost more fun to see what you're thinking.
I don't know what I'm doing. I have a question, jumping back to the MEJC. Are there any state's attorneys represented?
I can only speak for the committee that I am a member of, which is one of 7 committees, I believe, if I'm stated correctly. Katie, please help me out here. And there are prosecutors, state's attorneys. There's deputy state's attorney from Prince George's County is on that committee.
Yeah.
And there's another prosecutor as well. But Katie might be able to speak to some of the others.
Yeah, so on our committee, Jason Abbott and Perry Paler are on our committee. But on the collaborative, Karen Piper Mitchell is a member of the collaborative on behalf of MSAA. They got together and decided who they wanted as the collaborative. I will say though, I had kind of said to Jason and others, I think we'd be happy to have more participation. So I think Karen is doing a great job as a collaborative member. And then on individual committees, I think I can't say that every committee has prosecutors. I don't know that they don't, but I don't know for a fact that they do. So I think if there's interest, please reach out. Again, I mean, each committee is co-chaired by somebody from the Attorney General's office. So of course, most of our office, I happen to do prosecution, but most of our office does not. So most of our office are not prosecutors, and then co-chaired by somebody from the Public Defender's office. And then also from our third-party educational partners. So the Public Defender's office is obviously very represented, and I think we sort of hope to get some more state attorney participation in the beginning. I think it's okay now, but if there's any interest, or you are interested, or anybody in your office, even just joining the committees, we're happy to have more people.
I just wanted to bring it to the attention of the Maryland State's Attorneys Association, just to make sure there's no one else.
They are aware. So that's who we went through MSAA to get a nominee for the collaborative. Okay. So that's how they nominated Karen Piper Mitchell. So they're aware. I go to those board meetings, and I've talked about it a couple of times, not at this last one, but and Jason obviously is there too. And Jason is sort of who I go to make sure that, like MSAA is in the loop on stuff, but yeah.
Okay. Thank you.
Yep.
Thank you. Any additional questions, announcements? Any new business? All right, well, thank you all for joining us this evening. Do I have a motion to adjourn? Mr. Finch, Mr. Finch, any second? I don't even know if we need a second. All right, thank you, Judge DeLeonardo. All right, thank you all. You all have a great night. Thank you for all of your hard work, and we'll see you in December.
Yes, thank you, everyone. Have a great evening.